Book 5, Labor Relations, Title 1, Policy and Definitions, Chapter 1, Policy, 218, Declaration of Policy. A. It is the policy of the state, A. To promote and emphasize the primacy of free collective bargaining and negotiations, including voluntary arbitration, mediation, and conciliation as modes of settling labor or industrial disputes. B. To promote free trade unionism as an instrument for the enhancement of democracy and the promotion of social justice and development. C. To foster the free and voluntary organization of a strong and united labor movement. D. To promote the enlightenment of workers concerning their rights and obligations as union members and as employees. E. To provide an adequate administrative machinery for the expeditious settlement of labor or industrial disputes. F. To ensure a stable but dynamic and just industrial peace, and G. To ensure the participation of workers in decision and policy-making processes affecting their rights, duties, and welfare. B. To encourage a truly democratic method of regulating the relations between the employers and employees by means of agreements freely entered into through collective bargaining. No court or administrative agency or official shall have the power to set or fix wages, rates of pay, hours of work, or other terms and conditions of employment except as otherwise provided under this code. Chapter 2. Definitions. 219. Definitions. A. Commission means the National Labor Relations Commission or any of its divisions, as the case may be, as provided under this code. B. Bureau means the Bureau of Labor Relations and or the Labor Relations Division in the regional offices established under Presidential Decree No. 1 in the Department of Labor. C. Board means the National Conciliation and Mediation Board established under Executive Order No. 126. D. Council means a tripartite voluntary arbitration advisory council established under Executive Order No. 126 as amended. E. Employer includes any person acting in the interest of an employer, directly or indirectly. The term shall not include any labor organization or any of its officers or agents except when acting as employer. F. Employee includes any person in the employ of an employer. The term shall not be limited to the employees of a particular employer, unless the code so explicitly states. It shall include any individual whose work has ceased as a result of or in connection with any current labor dispute or because of any unfair labor practice if he has not obtained any other substantially equivalent and regular employment. G. Labor organization means any union or association of employees which exists in whole or in part for the purpose of collective bargaining or of dealing with employers concerning terms and conditions of employment. H. Legitimate labor organization means any labor organization duly registered with the Department of Labor and Employment and includes any branch or local thereof. I. Company union means any labor organization whose formation, function, or administration has been assisted by any act defined as unfair labor practice by this code. J. Bargaining representative means a legitimate labor organization whether or not employed by the employer. K. Unfair labor practice means any unfair labor practice as expressly defined by the code. L. Labor dispute includes any controversy or matter concerning terms and conditions of employment or the association or representation of persons in negotiating, fixing, maintaining, changing, or arranging the terms and conditions of employment, regardless of whether the disputants stand in the proximate relation of employer and employee. M. Managerial employee is one who is vested with the powers or prerogatives to lay down and execute management policies and or to hire, transfer, suspend, lay off, recall, discharge, assign, or discipline employees. Supervisory employees are those who, in the interest of the employer, effectively recommend such managerial actions if the exercise of such authority is not merely routinary or clerical in nature, but requires the use of independent judgment. All employees not falling within any of the above definitions are considered rank-and-file employees for purposes of this book. N. Voluntary Arbitrator means any person accredited by the board as such or any person named or designated in the collective bargaining agreement by the parties to act as their voluntary arbitrator or one chosen with or without the assistance of the National Conciliation and Mediation Board pursuant to a selection procedure agreed upon in the collective bargaining agreement or any official that may be authorized by the Secretary of Labor and Employment to act as voluntary arbitrator upon the written request and agreement of the parties to a labor dispute. O. Strike means any temporary stoppage of work by the concerted action of employees as a result of an industrial or labor dispute. P. Lockout means any temporary refusal of an employer to furnish work as a result of an industrial or labor dispute. Q. Internal union dispute includes all disputes or grievances arising from any violation of or disagreement over any provision of the Constitution and bylaws of a union, including any violation of the rights and conditions of union membership provided for in this code. R. Strike breaker means any person who obstructs, impedes, or interferes with, by force, violence, coercion, threats, or intimidation, any peaceful picketing affecting wages, hours, or conditions of work, or in the exercise of the right of self-organization or collective bargaining. S. Strike area means the establishment, warehouses, depots, plants, or offices, including the sites or premises used as runaway shops, of the employer struck against, as well as immediate vicinity actually used by the picketing strikers in moving to and fro before all points of entrance to and exit from said establishment. Title 2. National Labor Relations Commission, Chapter 1, Creation and Composition. 220. National Labor Relations Commission. There shall be a National Labor Relations Commission which shall be attached to the Department of Labor and Employment solely for program and policy coordination, composed of a chairman and 23 members. 8 members each shall be chosen only from among the nominees of the workers' and employers' organizations, respectively. The chairman and the 7 remaining members shall come from the public sector, with the latter to be chosen preferably from among the incumbent labor arbiters. Upon assumption into office, the members nominated by the workers' and employers' organizations shall divest themselves of any affiliation with or interest in the federation or association to which they belong. The commission may sit en banc or in 8 divisions, each composed of 3 members. The Commission shall sit en banc only for the purposes of promulgating rules and regulations governing the hearing and disposition of cases before any of its divisions and regional branches, and formulating policies affecting its administration and operations. The Commission shall exercise its adjudicatory and all other powers, functions, and duties through its divisions. Of the 8 divisions, the first, second, third, fourth, fifth, and sixth divisions shall handle cases coming from the National Capital Region and other parts of Luzon, and the 7th and 8th Divisions cases from the Visayas and Mindanao, respectively, provided that the Commission sitting en banc may, on temporary or emergency basis, allow cases within the jurisdiction of any division to be heard and decided by any other division whose docket allows the additional workload, and such transfer will not expose litigants to unnecessary additional expense. The divisions of the Commission shall have exclusive appellate jurisdiction over cases within then respective territorial jurisdiction. The concurrence of 2 commissioners of a division shall be necessary for the pronouncement of judgment or resolution. Whenever the required membership in a division is not complete, and the concurrence of 2 commissioners to arrive at a judgment or resolution cannot be obtained, the chairman shall designate such number of additional commissioners from the other divisions as may be necessary. The conclusions of a division on any case submitted to it for decision shall be reached in consultation before the case is assigned to a member for the writing of the opinion. It shall be mandatory for the division to meet for purposes of the consultation ordained herein. A certification to this effect signed by the presiding commissioner of the division shall be issued, and a copy thereof attached to the record of the case and served upon the parties. The chairman shall be the presiding commissioner of the first division, and the 7 other members from the public sector shall be the presiding commissioners of the second, third, fourth, fifth, sixth, seventh, and eighth divisions, respectively. In case of the effective absence or incapacity of the chairman, the presiding commissioner of the second division shall be the acting chairman. The chairman, aided by the executive clerk of the commission, shall have administrative supervision over the commission and its regional branches and all its personnel, including the executive labor arbiters and labor arbiters. The commission, when sitting en banc, shall be assisted by the same executive clerk, and, when acting through its divisions, by said executive clerk. and when acting through its division by said executive clerk for its first division and 7 other deputy executive clerks for the second, third, fourth, fifth, sixth, seventh, and eighth divisions respectively, in the performance of such similar or equivalent functions and duties as are discharged by the clerk of court and deputy clerks of court of the Court of Appeals. The Commission and its 8 divisions shall be assisted by the Commission attorneys in its appellate and adjudicatory functions, whose terms shall be coterminous with the Commissioners with whom they are assigned. The Commission attorneys shall be members of the Philippine Bar with at least 1 year experience or exposure in the field of labor management relations. They shall receive annual salaries and shall be entitled to the same allowances and benefits as those falling under Salary Grade 26. There shall be as many commission attorneys as may be necessary for the effective and efficient operation of the commission, but in no case more than 5 assigned to the office of the chairman and each commissioner. 221. Headquarters, branches, and provincial extension units. The The Commission and its first, second, third, fourth, fifth, and sixth divisions shall have their main offices in Metropolitan Manila, and the seventh and eighth divisions in the cities of Cebu and Cagayan de Oro, respectively. The Commission shall establish as many regional branches as there are regional offices of the Department of Labor and Employment, sub-regional branches, or provincial extension units. There shall be as many labor arbiters as may be necessary for the effective and efficient operation of the Commission. Two, Appointment and Qualifications. The chairman and other commissioners shall be members of the Philippine Bar and must have engaged in the practice of law in the Philippines for at least 15 years, with at least 5 years' experience or exposure in the field of labor management relations, and shall preferably be residents of the region where they are to hold office. The labor arbiters shall likewise be members of the Philippine Bar and must have been engaged in the practice of law in the Philippines for at least 10 years with at least 5 years' experience or exposure in the field of labor management relations. The chairman and other commissioners and the labor arbiters shall hold office during good behavior until they reach the age of 65 years, unless sooner removed for cause as provided by law or become incapacitated to discharge the duties of their office, provided, however, that the President of the Republic of the Philippines may extend the services of the commissioners and labor arbiters up to the maximum age of 70 years upon the recommendation of the Commission and Bank. The chairman, the division presiding commissioners, and other commissioners shall be appointed by the President. Appointment to any vacancy shall come from the nominees of the sector which nominated the predecessor. The labor arbiters shall also be appointed by the President upon the recommendation of the Commission and Bank and shall be subject to the civil service law, rules, and regulations. The chairman of the commission shall appoint the staff and employees of the commission and its regional branches as the needs of the service may require, subject to the civil service law, rules, and regulations, and upgrade their current salaries, benefits, and other emoluments in accordance with law. 223. Salaries, benefits, and other emoluments. The chairman and members of the commission shall have the same rank, receive an annual salary equivalent to, and be entitled to the same allowances, retirement, and benefits as those of the presiding justice and associate justices of the Court of Appeals, respectively. Labor arbiters shall have the same rank, receive an annual salary equivalent to, and be entitled to the same allowances, retirement, and other benefits and privileges as those of the judges of the regional trial courts. In no case, however, shall the provision of this article result in the diminution of the existing salaries, allowances, and benefits of the aforementioned officials. Chapter 2. Powers and Duties. 224. Jurisdiction of the labor arbiters and the Commission. A. Except as those provided under this code, the labor arbiters shall have original and exclusive jurisdiction to hear and decide within 30 calendar days after the submission of the case by the parties for decision without extension, even in the absence of stenographic notes, the following cases involving all workers, whether agricultural or non-agricultural. 1. Unfair labor practice cases. 2. Termination disputes. 3. If accompanied with a claim for reinstatement. those cases that workers may file involving wages, rates of pay, hours of work, and other terms and conditions of employment. 4. Claims for actual, moral, exemplary, and other forms of damages arising from the employer-employee relations. 5. Cases arising from any violation of Article 264 of this code, including questions involving the legality of strikes and lockouts. And 6. Except claims for employees' compensation, Social Security, Medicare, and maternity benefits, all other claims arising from employer-employee relations, including those of persons in domestic or household service, involving an amount exceeding 5,000 pesos, regardless of whether accompanied with a claim for reinstatement. B. The Commission shall have exclusive appellate jurisdiction over all cases decided by labor arbiters. C. Cases arising from the interpretation or implementation of collective bargaining agreements and those arising from the interpretation or enforcement of company personnel policies shall be disposed of by the labor arbiter by referring the same to the grievance machinery and voluntary arbitration as may be provided in said agreements. 225. Powers of the Commission. The Commission shall have the power and authority: a. To promulgate rules and regulations governing the hearing and disposition of cases before it and its regional branches, as well as those pertaining to its internal functions, and such rules and regulations as may be necessary to carry out the purposes of this code. B. To administer oaths, summon the parties to a controversy, issue subpoenas requiring the attendance and testimony of witnesses or the production of such books, papers, contracts, records, statement of accounts, agreements, and others as may be material to a just determination of the matter under investigation, and to testify in any investigation or hearing conducted in pursuance of this code. C. To conduct investigation for the determination of a question, matter, or controversy within its jurisdiction, proceed to hear and determine the disputes in the absence of any party thereto who has been summoned or served with notice to appear, conduct its proceedings or any part thereof in public or in private, adjourn its hearings to any time and place, refer technical matters or accounts to an expert, and to accept his report as evidence after hearing of the parties upon due notice, direct parties to be joined in or excluded from the proceedings, correct, amend, or waive any error, defect, or irregularity, whether in substance or in form, give all such directions as it may deem necessary or expedient in the determination of the dispute before it, and dismiss any matter or refrain from further hearing or from determining the dispute or part thereof, where it is trivial or where further proceedings by the Commission are not necessary or desirable, and D. To hold any person in contempt directly or indirectly and impose appropriate penalties therefore in accordance with law. A person guilty of misbehavior in the presence of or so near the chairman or any member of the Commission or any labor arbiter as to obstruct or interrupt the proceedings before the same, including disrespect toward said officials, offensive personalities toward others, or refusal to be sworn or to answer as a witness or to subscribe an affidavit or deposition when lawfully required to do so, may be summarily adjudged in direct contempt by said officials and punished by fine not exceeding 500 pesos or imprisonment not exceeding 5 days or both, if it be the Commission or a member thereof, or by a fine not exceeding 100 pesos or imprisonment not exceeding 1 day or both if it be a labor arbiter. The person adjudged in direct contempt by a labor arbiter may appeal to the Commission, and the execution of the judgment shall be suspended pending the resolution of the appeal upon the filing by such person of a bond on condition that he will abide by and perform the judgment of the Commission should the appeal be decided against him. Judgment of the Commission on direct contempt is immediately executory and unappealable. Indirect contempt shall be dealt with by the Commission or labor arbiter in the manner prescribed under Rule 71 of the Revised Rules of Court. And E. To enjoin or restrain any actual or threatened commission of any or all prohibited or unlawful acts, or to require the performance of a particular act in any labor dispute, which, if not restrained or performed forthwith, may cause grave or irreparable damage to any party or render ineffectual any decision in favor of such party, provided that no temporary or permanent injunction in any case involving or growing out of a labor dispute, as defined in this code, shall be issued except after hearing the testimony of witnesses, the opportunity for cross-examination, in support of the allegations of a complaint made under oath and testimony in opposition thereto if offered, and only after a finding of fact by the Commission to the effect 1. That prohibited or unlawful acts have been threatened and will be committed and will be continued unless restrained, but no injunction or temporary restraining order shall be issued on account of any threat, prohibited or unlawful act except against a person or persons, association or organization making the threat or committing the prohibited or unlawful act or actually authorizing or ratifying the same after actual knowledge thereof. 2. That substantial and irreparable injury to complainant's property will follow. 3. That as to each item of relief to be granted, greater injury will be inflicted upon complainant by the denial of relief than will be inflicted upon defendants by the granting of relief. 4. That complainant has no adequate remedy at law. And 5. That the public officers charged with the duty to protect complainant's property are unable or unwilling to furnish adequate protection. Such hearing shall be held after due and personal notice thereof has been served in such manner as the Commission shall direct to all known persons against whom relief is sought, and also to the Chief Executive and other public officials of the province or city within which the unlawful acts have been threatened or committed, charged with the duty to protect complainant's property. Provided, however, that if a complainant shall also allege that, unless a temporary restraining order shall be issued without notice, a substantial and irreparable injury to complainant's property will be unavoidable, such a temporary restraining order may be issued upon testimony under oath sufficient if sustained to justify the Commission in issuing a temporary injunction upon hearing after notice. Such a temporary restraining order shall be effective for no longer than 20 days and shall become void at the expiration of said 20 days. No such temporary restraining order or temporary injunction shall be issued, except on condition that complainant shall first file an undertaking with adequate security in an amount to be fixed by the Commission, sufficient to recompense those enjoined for any loss, expense, or damage caused by the improvident or erroneous issuance of such order or injunction, including all reasonable costs, together with a reasonable attorney's fee and expense of defense against the order or against the granting of any injunctive relief sought in the same proceeding and subsequently denied by the Commission. The undertaking herein mentioned shall be understood to constitute an agreement entered into by the complainant and the surety upon which an order may be rendered in the same suit or proceeding against said complainant and surety upon a hearing to assess damages, of which hearing complainant and surety shall have reasonable notice, the said complainant and surety submitting themselves to the jurisdiction of the Commission for that purpose, but nothing herein contained shall deprive any party having a claim or cause of action under or upon such undertaking from electing to pursue his ordinary remedy by suit at law or in equity, provided further that the reception of evidence for the application of a writ of injunction may be delegated by the Commission to any of its labor arbiters, who shall conduct such hearings in such places as he may determine to be accessible to the parties and their witnesses, and shall submit thereafter his recommendation to the Commission. 226. Ocular Inspection. The chairman, any commissioner, labor arbiter, or their duly authorized representatives may, at any time during working hours, conduct an ocular inspection on any establishment, building, ship, or vessel, place or premises, including any work, material, implement, machinery, appliance, or any object therein, and ask any employee, laborer, or any person, as the case may be, for any information or data concerning any matter or question relative to the object of the investigation. 227. Technical rules not binding and prior resort to amicable settlement. In any proceeding before the Commission or any of the labor arbiters, the rules of evidence prevailing in courts of law or equity shall not be controlling, and it is the spirit and intention of this code that the Commission and its members and the labor arbiters shall use every and all reasonable means to ascertain the facts in each case speedily and objectively, and without regard to technicalities of law or procedure, all in the interest of due process. In any proceeding before the Commission or any labor arbiter, the parties may be represented by legal counsel, but it shall be the duty of the chairman, any presiding commissioner, or any labor arbiter to exercise complete control of the proceedings at all stages. Any provision of law to the contrary notwithstanding, the labor arbiter shall exert all efforts towards the amicable settlement of a labor dispute within his jurisdiction on or before the first hearing. The same rule shall apply to the Commission in the exercise of its original jurisdiction. 228. Appearance and fees. A. Non-lawyers may appear before the Commission or any labor arbiter only. B. No attorney's fees, negotiation fees, or similar charges of any kind arising from any collective bargaining agreement shall be imposed on any individual member of the contracting union, provided, however, that attorney's fees may be charged against union funds in an amount to be agreed upon by the parties. Any contract, agreement, or arrangement of any sort to the contrary shall be null and void. Chapter 3 Appeal 229 Appeal Decisions, awards, or orders of the labor arbiter are final and executory unless appealed to the Commission by any or both parties within 10 calendar days from receipt of such decisions, awards, or orders. Such appeal may be entertained only on any of the following grounds. A. If there is prima facie evidence of abuse of discretion on the part of the labor arbiter. B. If the decision, order, or award was secured through fraud or coercion, including graft and corruption. C. If made purely on questions of law. And D. If serious errors in the findings of fact are raised which would cause grave or irreparable damage or injury to the appellant. In case of a judgment involving a monetary award, an appeal by the employer may be perfected only upon the posting of a cash or surety bond issued by a reputable bonding company duly accredited by the Commission in the amount equivalent to the monetary award in the judgment appealed from. In any event, the decision of the labor arbiter reinstating a dismissed or separated employee, insofar as the reinstatement aspect is concerned, shall immediately be executory. Even pending appeal, the employee shall either be admitted back to work under the same terms and conditions prevailing prior to his dismissal or separation, or at the option of the employer, merely reinstated in the payroll. The posting of a bond by the employer shall not stay the execution for reinstatement provided herein. To discourage frivolous or dilatory appeals, the Commission or the labor arbiter shall impose reasonable penalty, including fines or censures, upon the erring parties. In all cases, the appellant shall furnish a copy of the memorandum of appeal to the other party, who shall file an answer not later than 10 calendar days from receipt thereof. The Commission shall decide all cases within 20 calendar days from receipt of the answer of the appellee. The decision of the Commission shall be final and executory after 10 calendar days from receipt thereof by the parties. Any law enforcement agency may be deputized by the Secretary of Labor and Employment or the Commission in the enforcement of decisions, awards, or orders. 230. Execution of decisions, orders, or awards. A. Secretary of Labor and Employment or any regional director, the Commission or any labor arbiter or med-arbiter or voluntary arbiter may, motu proprio or on the motion of any interested party, issue a writ of execution on a judgment within 5 years from the date it becomes final and executory, requiring a sheriff or a duly deputized officer to execute or enforce final decisions, orders, or awards of the Secretary of Labor and Employment or Regional Director, the Commission, the Labor Arbiter or Med-Arbiter, or Voluntary Arbitrators. In any case, it shall be the duty of the responsible officer to separately furnish immediately the counsels of record and the parties with copies of said decisions, orders, or awards. Failure to comply with the duty prescribed herein shall subject such responsible officer to appropriate administrative sanctions. B. The Secretary of Labor and Employment and the Chairman of the Commission may designate special sheriffs and take any measure under existing laws to ensure compliance with their decisions, orders, or awards and those of the labor arbiters and voluntary arbiters, including the imposition of administrative fines which shall not be less than 500 nor more than 10,000 pesos. 231. Contempt powers of the Secretary of Labor. In the exercise of his powers under this code, the Secretary of Labor may hold any person in direct or indirect contempt and impose the appropriate penalties therefore. Title 3. Bureau of Labor Relations. 232. Bureau of Labor Relations. The Bureau of Labor Relations and the Labor Relations Divisions in the regional offices of the Department of Labor shall have original and exclusive authority to act at their own initiative or upon request of either or both parties on all inter-union and intra-union conflicts and all disputes, grievances, or problems arising from or affecting labor management relations in all workplaces, whether agricultural or non-agricultural, except those arising from the implementation or interpretation of collective bargaining agreements, which shall be the subject of grievance procedure and/or voluntary arbitration. The Bureau shall have 15 working days to act on labor cases before it, subject to extension by agreement of the parties. 233. Compromise agreements. Any compromise settlement, including those involving labor standard laws, voluntarily agreed upon by the parties with the assistance of the Bureau or the regional office of the Department of Labor, shall be final and binding upon the parties. The National Labor Relations Commission or any court shall not assume jurisdiction over issues involved therein except in case of non-compliance thereof or if there is prima facie evidence that the settlement was obtained through fraud, misrepresentation, or coercion. 234. Mandatory conciliation and endorsement of cases. A. Except as provided in Title 7A, Book 5 of this Code as amended or as may be executed by the Secretary of Labor and Employment, all issues arising from labor and employment shall be subject to mandatory conciliation mediation. The labor arbiter or the appropriate doles, agency, or office that has jurisdiction over the dispute shall entertain only endorsed or referred cases by the duly authorized officer. B. Any or both parties involved in the dispute may pre-terminate the conciliation mediation proceedings and request referral or endorsement to the appropriate dole, agency, or office which has jurisdiction over the dispute, or if both parties so agree, refer the unresolved issues to voluntary arbitration. 235. Assurance of subpoenas. The Bureau shall have the power to require the appearance of any person or the production of any paper, document, or matter relevant to a labor dispute under its jurisdiction, either at the request of any interested party or at its own initiative. 236. Appointment of Bureau personnel. The Secretary of Labor and Employment may appoint, in addition to the present personnel of the Bureau and the Industrial Relations Divisions, such number of examiners and other assistants as may be necessary to carry out the purpose of the Code. 237. Registry of Unions and File of Collective Bargaining Agreements. The Bureau shall keep a registry of legitimate labor organizations. The Bureau shall also maintain a file of all collective bargaining agreements and other related agreements and records of settlement of labor disputes and copies of orders and decisions of voluntary arbitrators. The file shall be open and accessible to interested parties under conditions prescribed by the Secretary of Labor and Employment, provided that no specific information submitted in confidence shall be disclosed unless authorized by the Secretary, or when it is at issue in any judicial litigation, or when public interest or national security so requires. Within 30 days from the execution of a collective bargaining agreement, the parties shall submit of the same directly to the Bureau or the regional offices of the Department of Labor and Employment for registration, accompanied with verified proofs of its posting in two conspicuous places in the place of work and ratification by the majority of all the workers in the bargaining unit. The Bureau or regional offices shall act upon the application for registration of such collective bargaining agreement within 5 calendar days from receipt thereof. The regional offices shall furnish the Bureau with a copy of the collective bargaining agreement within 5 days from its submission. The Bureau or regional office shall assess the employer for every collective bargaining agreement a registration fee of not less than 1,000 pesos or in any other amount as may be deemed appropriate and necessary by the Secretary of Labor and Employment for the effective and efficient administration of the voluntary arbitration program. Any amount collected under this provision shall accrue to the Special Voluntary Arbitration Fund. The Bureau shall also maintain a file and shall undertake or assist in the publication of all final decisions, orders, and awards of the Secretary of Labor and Employment, Regional Directors, and the Commission. 238. Prohibition on Certification Election. The Bureau shall not entertain any petition for certification election or any other action which may disturb the administration of duly registered existing collective bargaining agreements affecting the parties except under Articles 264, 265, and 268 of this Code. 239. Privileged Communication. Information and statements made at conciliation proceedings shall be treated as privileged communication and shall not be used as evidence in the commission. Conciliators and similar officials shall not testify in any court or body regarding any matters taken up at conciliation proceedings conducted by them. Title 4 Labor Organizations, Chapter 1 Registration and Cancellation. 240 Requirements of Registration. Any applicant, labor organization, association, or group of unions or workers shall acquire legal personality and shall be entitled to the rights and privileges granted by law to legitimate labor organizations upon issuance of the certificate of registration based on the following requirements. A. 50 pesos registration fee. B. The names of its officers, their addresses, the principal address of the labor organization, the minutes of the organizational meetings, and the list of the workers who participated in such meetings. C. In case the applicant is an independent union, the names of all its members comprising at least 20% of all the employees in the bargaining unit where it seeks to operate. D. If the applicant union has been in existence for 1 or more years, copies of its annual financial reports, and E. 4 copies of the Constitution and bylaws of the applicant union, minutes of its adoption or ratification, and the list of the members who participated in it. 241. Chartering and creation of a local chapter. A duly registered federation or national union may directly create a local chapter by issuing a charter certificate indicating the establishment of the local chapter. The chapter shall acquire legal personality only for purposes of filing a petition for certification election from the date it was issued as charter certificate. The chapter shall be entitled to all other rights and privileges of a legitimate labor organization only upon the submission of the following documents in addition to its charter certificate. A. The names of the chapter's officers, their addresses, and the principal office of the chapter, and B. The chapter's constitution and bylaws, provided that where the chapter's constitution and bylaws are the same as that of the federation or the national union, this fact shall be indicated accordingly. The additional supporting requirements shall be certified under oath by the secretary or treasurer of the chapter and attested by its president. 242. Action on application. The Bureau shall act on all applications for registration within 30 days from filing. All requisite documents and papers shall be certified under oath by the secretary or the treasurer of the organization, as the case may be, and attested to by its president. 243. Denial of registration. Appeal. The decision of the Labor Relations Division in the regional office denying registration may be appealed by the applicant union to the Bureau within 10 days from receipt of notice thereof. 244. Additional requirements for federations or national unions. Subject to Article 238, now Article 244, if the applicant for registration is a federation or a national union, it shall, in addition to the requirements of the preceding articles, submit the following. A. Proof of the affiliation of at least 10 locals or chapters, each of which must be a duly recognized collective bargaining agent in the establishment or industry in which it operates, supporting the registration of such applicant, federation, or national union. And B. The names and addresses of the companies where the locals or chapters operate, and the list of all the members in each company involved. 245. Cancellation for registration. The certification of registration of any legitimate labor organization, whether national or local, may be cancelled by the Bureau after due hearing only on the grounds specified in Article 239. 2 for 6. Effect of a petition for cancellation of registration. A petition for cancellation of union registration shall not suspend the proceedings for certification election, nor shall it prevent the filing of a petition for certification election. In case of cancellation, nothing herein shall restrict the right of the union to seek just and equitable remedies in the appropriate courts. 2 for 7. Grounds for cancellation of union registration. The following may constitute grounds for cancellation of union registration. A. Misrepresentation, false statement, or fraud in connection with the adoption or ratification of the Constitution and bylaws or amendments thereto, the minutes of ratification, and the list of members who took part in the ratification. B. Misrepresentation, false statements, or fraud in connection with the election of officers, minutes of the election of officers, and the list of voters. C. Voluntary dissolution by the members. 2 for 8. Voluntary cancellation of registration. The registration of a legitimate labor organization may be cancelled by the organization itself, provided that at least 2/3 of its general membership votes in a meeting duly called for that purpose to dissolve the organization, provided further that an application to cancel registration is thereafter submitted by the board of the organization, attested to by the president thereof. 2 for 9. Equity of the incumbent. All existing federations and national unions which meet the qualifications of a legitimate labor organization and none of the grounds for cancellation shall continue to maintain their existing affiliates, regardless of the nature of the industry and the location of the affiliates. Chapter 2. Rights and conditions of membership. 250. Rights and conditions of membership in a labor organization. The following are the rights and conditions of membership in a labor organization. A. No arbitrary or excessive initiation fees shall be required of the members of a legitimate labor organization, nor shall arbitrary, excessive, or oppressive fine and forfeit shall be imposed. B. The members shall be entitled to full and detailed reports from their officers and representatives of all financial transactions as provided for in the Constitution and bylaws of the organization. C. The members shall directly elect their officers, including those of the national union or federation to which they or their union is affiliated, by secret ballot at intervals of 5 years. No qualification requirements for candidacy to any position shall be imposed other than membership in good standing in subject labor organization. The Secretary or any other responsible union officer shall furnish the Secretary of Labor and Employment with the list of the newly elected officers, together with the appointive officers or agents who are entrusted with the handling of funds within 30 calendar days after the election of officers or from the occurrence of any change in the list of officers of the labor organization. D. The members shall determine by secret ballot after due deliberation any question of major policy affecting the entire membership of the organization, unless the nature of the organization or force majeure renders such secret ballot impractical, in which case the board of directors of the organization may make the decision in behalf of the general membership. A. E. No labor organization shall knowingly admit as members or continue in membership any individual who belongs to a subversive organization or who is engaged directly or indirectly in any subversive activity. F. No person who has been convicted of a crime involving moral turpitude shall be eligible for election as a union officer or for appointment to any position in the union. G. No officer, agent, or member of a labor organization shall collect any fees, dues, or other contribution in its behalf, or make any disbursement of its money or funds unless he is duly authorized pursuant to its constitution and bylaws. H. Every payment of fees, dues, or other contributions by a member shall be evidenced by a receipt signed by the officer or agent making the collection and entered into the record of the organization to be kept and maintained for the purpose. I. The funds of the organization shall not be applied for any purpose or object other than those expressly provided by its constitution and bylaws or those expressly authorized by written resolution adopted by the majority of the members at a general meeting duly called for the purpose. J. Every income or revenue of the organization shall be evidenced by a record showing its source, and every expenditure of its funds shall be evidenced by a receipt from the person to whom the payment is made, we shall state the date, place and purpose of such payment. Such record or receipt shall form part of the financial records of the organization. Any action involving the funds of the organization shall prescribe after 3 years from the date of submission of the annual financial report to the Department of Labor and Employment, or from the date the same should have been submitted, as required by law, whichever comes earlier, provided that this provision shall apply only to a legitimate labor organization which has submitted the financial report requirements under this code, provided further that failure of any labor organization to comply with the periodic financial reports required by law and such rules and regulations promulgated thereunder 6 months after the effectivity of this act shall automatically result in the cancellation of union registration of such labor organization. K. The officers of any labor organization shall not be paid any compensation other than the salaries and expenses due to their positions as specifically provided for in its constitution and bylaws, or in a written resolution duly authorized by a majority of all members at a general membership meeting duly called for the purpose. The minutes of the meeting and the list of participants and ballots cast shall be subject to inspection by the Secretary of Labor or his duly authorized representatives. Any irregularities in the approval of the resolutions shall be a ground for impeachment or expulsion from the organization. L. The treasurer of any labor organization and every officer thereof who is responsible for the account of such organization or for the collection, management, disbursement, custody, or control of the funds, monies, and other properties of the organization shall render to the organization and to its members a true and correct account of all monies received and paid by him since he assumed office or since the last day on which he rendered such account, and of all bonds, securities, and other properties of the organization entrusted to his custody or under his control. The rendering of such account shall be made 1. At least once a year within 30 days after the close of its fiscal year. 2. At such other times as may be required by a resolution of the majority of the members of the organization. And 3. Upon vacating his office. The account shall be duly audited and verified by affidavit, and a copy thereof shall be furnished to the Secretary of Labor and Employment. M. The books of accounts and other records of the financial activities of any labor organization shall be open to inspection by any officer or member thereof during office hours. N. No special assessment or other extraordinary fees may be levied upon the members of a labor organization unless authorized by a written resolution of a majority of all the members in a general membership meeting duly called for the purpose. The secretary of the organization shall record the minutes of the meeting, including the list of all members present, the votes cast, the purpose of the special assessment or fees, and the recipient of such assessment or fees. The record shall be attested to by the president. O. Other than for mandatory activities under the Code, no special assessments, attorney's fees, negotiation fees, or any other extraordinary fees may be checked off from any amount due to an employee without an individual written authorization duly signed by the employee. The authorization shall specifically state the amount, purpose, and beneficiary of the deduction. P. It shall be the duty of any labor organization and its officers to inform its members on the provisions of its constitution and bylaws, collective bargaining agreement, the prevailing labor relation system, and all the rights and obligations under existing labor laws. For this purpose, registered labor organizations may assess reasonable dues to finance labor relations seminars and other labor education activities. Any violation of the above rights and conditions of membership shall be a ground for cancellation of union registration or expulsion of officers from office, whichever is appropriate. At least 30% of the members of a union or any member or members specially concerned may report such violation to the Bureau. The Bureau shall have the power to hear and decide any reported violation to meet the appropriate penalty. Criminal and civil liabilities arising from violations of above rights and conditions of membership shall continue to be under the jurisdiction of ordinary courts. Chapter 3. Rights of Legitimate Labor Organizations. 251. Rights of Legitimate Labor Organizations. A legitimate labor organization shall have the right: A. to act as the representative of its members for the purpose of collective bargaining. B. To be certified as the exclusive representative of all the employees in an appropriate bargaining unit for purposes of collective bargaining. C. To be furnished by the employer, upon written request, with its annual audited financial statements, including the balance sheet and the profit and loss statement, within 30 calendar days from the date of receipt of the request, after the union has been duly recognized by the employer or certified as the sole and exclusive bargaining representative of the employees in the bargaining unit, or within 60 calendar days before the expiration of the existing collective bargaining agreement or during the collective bargaining negotiation. D. To own property, real or personal, for the use and benefit of the labor organization and its members. E. To sue and be sued in its registered name. And F. To undertake all other activities designed to benefit the organization and its members, including cooperative, housing, welfare, and other projects not contrary to law. Notwithstanding any provision of a general or special law to the contrary, the income and the properties of legitimate labor organizations, including grants, endowments, gifts, donations, and contributions they may receive from fraternal and similar organizations, local or foreign, which are actually directly and exclusively used for their lawful purposes, shall be free from taxes, duties, and other assessments. The exemptions provided herein may be withdrawn only by a special law expressly repealing this provision. 252. Repertorial Requirements. The following are documents required to be submitted to the Bureau by the legitimate labor organization concerned. A. Its constitution and bylaws or amendments thereto, the means of ratification, and the list of members who took part in the ratification of the Constitution and bylaws within 30 days from adoption or ratification of the Constitution and bylaws or amendments thereto. B. Its list of officers, minutes of the election of officers, and list of voters within 30 days from election. C. Its annual financial report within 30 days after the close of every fiscal year. And D. Its list of members at least once a year or whenever required by the Bureau. Failure to comply with above requirements shall not be a ground for cancellation of union registration, but shall subject the erring officers or members to suspension, expulsion from membership, or any appropriate penalty. Title 5 Coverage 253 Coverage and Employees' Right to Self-Organization. All persons employed in commercial, industrial, and agricultural enterprises and in religious, charitable, medical, or educational institutions, whether operating for profit or not, shall have the right to self-organization and to form, join, or assist labor organizations of their own choosing for purposes of collective bargaining. Ambulant, intermittent, and itinerant workers, self-employed people, rural workers, and those without any definite employers may form labor organizations for their mutual aid and protection. 254. Right of employees in the public service. Employees of government corporations established under the Corporation Code shall have the right to organize and to bargain collectively with their respective employers. All other employees in the civil service shall have the right to form associations for purposes not contrary to law. 255. Ineligibility of managerial employees to join any labor. Right of supervisory employees. Managerial employees are not eligible to join, assist, or form any labor organization. Supervisory employees shall not be eligible for membership in the collective bargaining unit of the rank and file employees, but may join, assist, or form separate collective bargaining units and/or legitimate labor organizations of their own. The rank and file union and the supervisors union operating within the same establishment may join the same federation or national union. 256. Effect of inclusion as members of employees outside the bargaining unit. The inclusion as union members of employees outside the bargaining unit shall not be a ground for the cancellation of the registration of the union. Said employees are automatically deemed removed from the list of membership of said union. 257. Non-abbrishment of right to self-organization. It shall be unlawful for any person to restrain, coerce, discriminate against, or unduly interfere with employees and workers in their exercise of the right to self-organization. Such rights shall include the right to form, join, or assist labor organizations for the purpose of collective bargaining through representatives of their own choosing, and to engage in lawful concerted activities for the same purpose for their mutual aid and protection, subject to the provisions of Article 264 of this Code. Title 6, Unfair Labor Practices, Chapter 1, Concept, 258. Concept of unfair labor practice and procedure for prosecution thereof. Unfair labor practices violate the constitutional right of workers and employees to self-organization, are inimical to the legitimate interests of both labor and management, including their right to bargain collectively and otherwise deal with each other in an atmosphere of freedom and mutual respect, disrupt industrial peace, and hinder the promotion of healthy and stable labor management relations. Consequently, unfair labor practices are not only violations of the civil rights of both labor and management, but are also criminal offenses against the state, which shall be subject to prosecution and punishment as herein provided, subject to the exercise by the President or by the Secretary of Labor and Employment of the powers vested in them by Articles 278 and 279 of this Code. The civil aspects of all cases involving unfair labor practices, which may include claims for actual, moral, exemplary, and other forms of damages, attorneys' fees, and other affirmative relief, shall be under the jurisdiction of the labor arbiters. The labor arbiters shall give utmost priority to the hearing and resolution of all cases involving unfair labor practices. They shall resolve such cases within 30 calendar days from the time they are submitted for decision. Recovery of civil liability in the administrative proceedings shall bar recovery under the Civil Code. No criminal prosecution under this title may be instituted without a final judgment finding that an unfair labor practice was committed, having been first obtained in the preceding paragraph. During the pendency of such administrative proceeding, the running of the period of prescription of the criminal offense herein penalized shall be considered interrupted, provided, however, that the final judgment in the administrative proceedings shall not be binding in the criminal case, nor be considered as evidence of guilt, but merely as proof of compliance of the requirements therein set forth. Chapter 2, Unfair Labor Practices of Employers, 259. Unfair labor practices of employers. It shall be unlawful for an employer to commit any of the following unfair labor practice. A. To interfere with, restrain, or coerce employees in the exercise of their right to self-organization. B. To require as a condition of employment that a person or an employee shall not join a labor organization or shall withdraw for one to which he belongs. C. To contract out services or functions being performed by union members when such will interfere with, restrain, or coerce employees in the exercise of their rights to self-organization. D. To initiate, dominate, assist, or otherwise interfere with the formation or administration of any labor organization, including the giving of financial or other support to it or its organizers or supporters. E. To discriminate in regard to wages, hours of work, and other terms and conditions of employment in order to encourage or discourage membership in any labor organization. Nothing in this code or in any other law shall stop the parties from requiring membership in a recognized collective bargaining agent as a condition for employment, except those employees who are already members of another union at the time of the signing of the collective bargaining agreement. Employees of an appropriate bargaining unit who are not members of the recognized collective bargaining agent may be assessed a reasonable fee equivalent to the dues and other fees paid by members of the recognized collective bargaining agent if such non-union members accept the benefits under the collective bargaining agreement, provided that the individual authorization required under Article 242, Paragraph O of this Code shall not apply to the non-members of the recognized collective bargaining agent. F. To dismiss, discharge, or otherwise prejudice or discriminate against an employee for having been given or being about to give testimony under this code. G. To violate the duty to bargain collectively as prescribed by this code. H. To pay negotiation or attorney's fees to the union or its officers or agents as part of the settlement of any issue in collective bargaining or any other dispute. Or I. To violate a collective bargaining agreement. The provisions of the preceding paragraph notwithstanding, only the officers and agents of corporations, associations, or partnerships who have actually participated in, authorized, or ratified unfair labor practices shall be held criminally liable. Chapter 3. Unfair Labor Practices of Labor Organizations. 260. Unfair Labor Practices of Labor Organizations. It shall be unfair labor practice for a labor organization, its officers, agents, or representatives, A. To restrain or coerce employees in the exercise of their right to self-organization. However, a labor organization shall have the right to prescribe its own rules with respect to the acquisition or retention of membership. B. To cause or attempt to cause an employer to discriminate against an employee, including discrimination against an employee with respect to whom membership in such organization has been denied, or to terminate an employee on any ground other than the usual terms and conditions under which membership or continuation of membership is made available to other members. C. To violate the duty or refuse to bargain collectively with the employer, provided it is the representative of the employees. D. To cause or attempt to cause an employer to pay or deliver or agree to pay or deliver any money or other things of value in the nature of an exaction for services which are not performed or not to be performed, including the demand for fee for union negotiations. E. To ask for or accept negotiation or attorney's fees from employers as part of the settlement of any issue in collective bargaining or any other dispute, or F. To violate a collective bargaining agreement. The provisions of preceding paragraph notwithstanding, only the officers, members of governing boards, representatives or agents or members of labor associations or organizations who have actually participated in, authorized, or ratified unfair labor practices shall be held criminally liable. Title 7. Collective Bargaining and Administration of Agreements. 261. Procedure in collective bargaining. The following procedures shall be observed in collective bargaining. A. When a party desires to negotiate an agreement, it shall serve a written notice upon the other party with a statement of its proposals. The other party shall make a reply thereto not later than 10 calendar days from receipt of such notice. B. Should differences arise on the basis of such notice and reply, either party may request for a conference which shall begin not later than 10 calendar days from the date of request. C. If the dispute is not settled, the board shall intervene upon request of either or both parties or at its own initiative and immediately call the parties to conciliation meetings. The board shall have the power to issue subpoenas requiring the attendance of the parties to such meetings. It shall be the duty of the parties to participate fully and promptly in the conciliation meetings the board may call. D. During the conciliation proceedings in the board, the parties are prohibited from doing any act which may disrupt or impede the early settlement of the disputes. And E. The board shall exert all efforts to settle disputes amicably and encourage the parties to submit their case to a voluntary arbitrator. 262. Duty to bargain collectively in the absence of collective bargaining agreements. In the absence of an agreement or other voluntary arrangement providing for a more expeditious manner of collective bargaining, it shall be the duty of employer and the representatives of the employees to bargain collectively in accordance with the provisions of this code. 263. Meaning of duty to bargain collectively. The duty to bargain collectively means the performance of a mutual obligation to meet and convene promptly and expeditiously in good faith for the purpose of negotiating an agreement with respect to wages, hours of work, and all other terms and conditions of employment, including proposals for adjusting any grievances or questions arising under such agreement, and executing a contract incorporating such agreements if requested by either party, but such duty does not compel any party to agree to a proposal or to make any concession. 264. Duty to bargain collectively when there exists a collective bargaining agreement. When there is a collective bargaining agreement, the duty to bargain collectively shall also mean that neither party shall terminate nor modify such agreement during its lifetime. However, either party can serve a written notice to terminate or modify the agreement at least 60 days prior to its expiration date. It shall be the duty of both parties to keep the status quo and to continue in full force and effect the terms and conditions of the existing agreement during the 60-day period and or until a new agreement is reached by the parties. 265. Terms of a collective bargaining agreement. Any collective bargaining agreement that the parties may enter into shall, insofar as the representation aspect is concerned, be for a term of 5 years. No petition questioning the majority status of the incumbent bargaining agent shall be entertained, and no certification election shall be conducted by the Department of Labor and Employment outside of the 60-day period immediately before the date of expiry of such 5-year term of the collective bargaining agreement. All other provisions of the collective bargaining agreement shall be renegotiated not later than 3 years after its execution. Any agreement on such other provisions of the collective bargaining agreement entered into within 6 months from the date of expiry of the term of such other provisions as fixed in such collective bargaining agreement shall retroact to the day immediately following such date. If any such agreement is entered into beyond 6 months, the parties shall agree on the duration of retroactivity thereof. In case of a deadlock in the renegotiation of the collective bargaining agreement, the parties may exercise their rights under this code. 266. Injunction Prohibited. No temporary or permanent injunction or restraining order in any case involving or growing out of labor disputes shall be issued by any court or other entity, except as otherwise provided in Articles 218 and 264 of this code. 267. Exclusive bargaining representation and workers' participation in policy and decision-making. The labor organization designated or selected by the majority of the employees in an appropriate collective bargaining unit shall be the exclusive representative of the employees in such unit for the purpose of collective bargaining. However, an individual employee or group of employees shall have the right at any time to present grievances to their employer. Any provision of law to the contrary notwithstanding, workers shall have the right, subject to such rules and regulations as the Secretary of Labor and Employment may promulgate, to participate in policy and decision-making processes of the establishment where they are employed in so far as said processes will directly affect their rights, benefits, and welfare. For this purpose, workers and employers may form labor management councils, provided that the representatives of the workers in such labor management councils shall be elected by at least a majority of all employees in said establishment. 268. Representation issue in organized establishments. In organized establishments, when a verified petition questioning the majority status of the incumbent bargaining agent is filed by any legitimate labor organization, including a national union or federation which has already issued a charter certificate to its local chapter, participating in the certification election, or a local chapter which has been issued a charter certificate by the national union or federation before the Department of Labor and Employment within the 60-day period before the expiration of the collective bargaining agreement, the mid-arbiter shall automatically order an election by secret ballot when the verified petition is supported by the written consent of at least 25% of all the employees in the bargaining unit to ascertain the will of the employees in the bargaining unit to ascertain the will of the employees in the appropriate bargaining unit. To have a valid election, at least a majority of all eligible voters in the unit must have cast their votes. The labor union receiving the majority of the valid votes cast shall be certified as the exclusive bargaining agent of all the workers in the unit. When an election which provides for 3 or more choices results in no choice receiving a majority of the valid votes cast, a runoff election shall be conducted between the labor unions receiving the 2 highest number of votes, provided that the total number of votes for all contending unions is at least 50% of the numbers of votes cast. In cases where the petition was filed by a national union or federation, it shall not be required to disclose the names of the local chapter's officers and members. At the expiration of the freedom period, the employer shall continue to recognize the majority status of the incumbent bargaining agent where no petition for certification election is filed. 269. Petitions in unorganized establishments. In any establishment where there is no certified bargaining agent, a certification election shall automatically be conducted by the mid-arbiter upon the filing of a petition by any legitimate labor organization, including a national union or federation, which has already issued a charter certificate to its local chapter participating in the certification election, or a local chapter, which has been issued a charter certificate by the national union or federation. In cases where the petition was filed by a national union or federation, it shall not be required to disclose the names of the local chapter's officers and members. 270. When an employer may file petition. When requested to bargain collectively, an employer may petition the Bureau for an election. If there is no existing certified collective bargaining agreement in the unit, the Bureau shall, after hearing, order a certification election. All certification cases shall be decided within 20 working days. The Bureau shall conduct a certification election within 20 days in accordance with the rules and regulations prescribed by the Secretary of Labor. 271. Employer as bystander. In all cases, whether the petitions for certification election is filed by an employer or a legitimate labor organization, the employer shall not be considered a party thereto with a concomitant right to oppose the petitions for certification election. The employer's participation in such proceedings shall be limited to 1. Being notified or informed of petitions of such nature, and 2. Submitting the list of employees during the pre-election conference should the mid-arbiter act favorably on the petition. 272. Appeal from certification election orders, as amended by Section 25 RA 6715, March 21, 1989. Title 7A, Grievance Machinery and Voluntary Arbitration. 273. Grievance Machinery and Voluntary Arbitration. The parties to a collective bargaining agreement shall include therein provisions that will ensure the mutual observance of its terms and conditions. They shall establish a machinery for the adjustment and resolution of grievances arising from the interpretation or implementation of their collective bargaining agreement and those arising from the interpretation or enforcement of company personnel policies. All grievances submitted to the grievance machinery which are not settled within 7 calendar days from the date of its submission shall automatically be referred to voluntary arbitration prescribed in the collective bargaining agreement. For this purpose, parties to a collective bargaining agreement shall name and designate in advance a voluntary arbitrator or panel of voluntary arbitrators, or include in the agreement a procedure for the selection of such voluntary arbitrator or panel of voluntary arbitrators, preferably from the listing of qualified voluntary arbitrators duly accredited by the board. In case the parties fail to select a voluntary arbitrator or panel of voluntary arbitrators, the board shall designate the voluntary arbitrator or panel of voluntary arbitrators as may be necessary, pursuant to the selection procedure agreed upon in the collective bargaining agreement, which shall act with the same force and effect as if the arbitrator or panel of arbitrators has been selected by the parties as described above. 274. Jurisdiction of voluntary arbitrators or panel of voluntary arbitrators. The voluntary arbitrator or panel of voluntary arbitrators shall have original and exclusive jurisdiction to hear and decide all unresolved grievances arising from the interpretation or implementation of the collective bargaining agreement, and those arising from the interpretation or enforcement of company personnel policies referred to in the immediately preceding article. Accordingly, violations of a collective bargaining agreement, except those which are gross in character, shall no longer be treated as unfair labor practice and shall be resolved as grievances under the collective bargaining agreement. For purposes of this article, gross violations of collective bargaining agreement shall mean flagrant and/or malicious refusal to comply with the economic provisions of such agreement. The Commission, its regional offices, and the regional directors of the Department of Labor and Employment shall not entertain disputes, grievances, or matters under the exclusive and original jurisdiction of the voluntary arbitrator or panel of voluntary arbitrators, and shall immediately dispose and refer the same to the grievance machinery or voluntary arbitration provided in the collective bargaining agreement. 275. Jurisdiction over other labor disputes. The voluntary arbitrator or panel of voluntary arbitrators, upon agreement of the parties, shall also hear and decide all other labor disputes, including unfair labor practices and bargaining deadlocks. 276. Procedures. The voluntary arbitrator or panel of voluntary arbitrators shall have the power to hold hearings, receive evidences, and take whatever action is necessary to resolve the issue or issues subject of the dispute, including efforts to effect a voluntary settlement between parties. All parties to the dispute shall be entitled to attend the arbitration proceedings. The attendance of any third party or the exclusion of any witness from the proceedings shall be determined by the voluntary arbitrator or panel of voluntary arbitrators. Hearing may be adjourned for cause or upon agreement by the parties. Unless the parties agree otherwise, it shall be mandatory for the voluntary arbitrator or panel of voluntary arbitrators to render an award or decision within 20 calendar days from the date of submission of the dispute to voluntary arbitration. The award or decision of the voluntary arbitrator or panel of voluntary arbitrators shall contain the facts and the law on which it is based. It shall be final and executory after 10 calendar days from receipt of the copy of the award or decision by the parties. Upon motion of any interested party, the voluntary arbitrator or panel of voluntary arbitrators or the labor arbiter in the region where the movement resides, in case of the absence or incapacity of the voluntary arbitrator or panel of voluntary arbitrators for any reason, may issue a writ of execution requiring either the sheriff, the commission, or regular courts, or any public official whom the parties may designate in the submission agreement to execute the final decision, order, or award. 277. Cost of voluntary arbitration and voluntary arbitrator's fee. The parties to a collective bargaining agreement shall provide therein a proportionate sharing scheme on the cost of voluntary arbitration, including the voluntary arbitrator's fee. The fixing of fee of voluntary arbitrators, whether shouldered wholly by the parties or subsidized by the Special Voluntary Arbitration Fund, shall take into account the following factors: A. Nature of the case. B. Time consumed in hearing the case. 3. Professional standing of the voluntary arbitrator. D. Capacity to pay of the parties. And E. Fees provided for in the revised rules of court. Title 8. Strikes and lockouts and foreign involvement in trade union activities. Chapter 1. Strikes and lockouts. 278. Strikes, picketing, and lockouts. A. It is the policy of the state to encourage free trade unionism and free collective bargaining. B. Workers shall have the right to engage in concerted activities for purposes of collective bargaining or for the mutual benefit and protection. The right of legitimate labor organizations to strike and picket and of employers to lock out, consistent with the national interest, shall continue to be recognized and respected. However, no labor union may strike and no employer may declare a lockout on grounds involving inter-union and intra-union disputes. C. In case of bargaining deadlocks, the duly certified or recognized bargaining agent may file a notice of strike or the employer may file a notice of lockout with the ministry at least 30 days before the intended date thereof. In cases of unfair labor practice, the period of notice shall be 15 days, and in the absence of a duly certified or recognized bargaining agent, the notice of strike may be filed by any legitimate labor organization in behalf of its employees. However, in case of dismissal from employment of union officers duly elected in accordance with the union constitution and bylaws, which may constitute union busting, where the existence of the union is threatened, the 15-day cooling-off period shall not apply and the union may take action immediately. D. The notice must be in accordance with such implementing rules and regulations as the Minister of Labor and Employment may promulgate. E. During the cooling-off period, it shall be the duty of the Ministry to exert all efforts at mediation and conciliation to effect a voluntary settlement. Should the dispute remain unsettled until the lapse of the requisite number of days from the mandatory filing of the notice, the labor union may strike or the employer may declare a lockout. F. A decision to declare a strike must be approved by a majority of the total union membership in the bargaining unit concerned, obtained by secret ballot in meetings or referenda called for that purpose. A decision to declare a lockout must be approved by a majority of the board of directors of the corporation or association or of the partners in a partnership, obtained by secret ballot in a meeting called for that purpose. The decision shall be valid for the duration of the dispute, based on substantially the same grounds considered when the strike or lockout vote was taken. The Ministry may, at its own initiative or upon the request of any affected party, supervise the conduct of the secret balloting. In every case, the union or the employer shall furnish the Ministry the results of the voting at least 7 days before the intended strike or lockout, subject to the cooling-off period herein provided. G. when, in his opinion, there exists a labor dispute causing or likely to cause a strike or lockout in an industry indispensable to the national interest, the Secretary of Labor and Employment may assume jurisdiction over the dispute and decide it or certify the same to the Commission for compulsory arbitration. Such assumption or certification shall have the effect of automatically enjoining the intended or impending strike or lockout as specified in the assumption or certification order. If one has already taken place at the time of assumption or certification, all striking or locked out employees shall immediately return to work, and the employer shall immediately resume operations and readmit all workers under the same terms and conditions prevailing before the strike or lockout. The Secretary of Labor and Employment or the Commission may seek the assistance of law enforcement agencies to ensure compliance with this provision as well as with such orders as he may issue to enforce the same. In line with the national concern for and the highest respect according to the right of patients to life and health, strikes and lockouts in hospitals, clinics, and similar medical institutions shall, to every extent possible, be avoided, and all serious efforts, not only by labor and management, but government as well, be exhausted to substantially minimize, if not prevent, their adverse effects on such life and health through the exercise, however legitimate, by labor of its right to strike and by management to lock out. In labor disputes adversely affecting the continued operation of such hospitals, clinics maintain an effective skeletal workforce of medical and other health personnel, whose movement and services shall be unhampered and restricted as are necessary to ensure the proper and adequate protection of the life and health of its patients, most especially emergency cases, for the duration of the strike or lockout. In such cases, therefore, the Secretary of Labor and Employment may immediately assume, within 24 hours from knowledge of the occurrence of such a strike or lockout, jurisdiction over the same or certify it to the Commission for compulsory arbitration. For this purpose, the contending parties are strictly enjoined to comply with such orders, prohibitions, and/or injunctions as are issued by the Secretary of Labor and Employment or the Commission, under pain of immediate disciplinary action, including dismissal or loss of employment status or payment by the locking out employer of back wages, damages, and other affirmative relief, even criminal prosecution against either or both of them. The foregoing notwithstanding, the President of the Philippines shall not be precluded from determining the industries that, in his opinion, are indispensable to the national interest, and from intervening at any time and assuming jurisdiction over any such labor dispute in order to settle or terminate the same. H. Before or at any stage of the compulsory arbitration process, the parties may opt to submit their dispute to voluntary arbitration. I. The Secretary of Labor and Employment, the Commission, or the voluntary arbitrator shall decide or resolve the dispute as the case may be. The decision of the President, the Secretary of Labor and Employment, the Commission, or the voluntary arbitrator shall be final and executory 10 calendar days after receipt thereof by the parties. 279. Prohibited Activities. A. No labor organization or employer shall declare a strike or lockout without first having bargained collectively and in accordance with Title VII of this book, or without first having filed the notice required in the preceding article, or without the necessary strike or lockout vote first having been obtained and reported to the Ministry. No strike or lockout shall be declared after assumption of jurisdiction by the President or the Minister or after certification or submission of the dispute to compulsory or voluntary arbitration or during the pendency of cases involving the same grounds for the strike or lockout. Any worker whose employment has been terminated as a consequence of any unlawful lockout shall be entitled to reinstatement with full back wages. Any union officer who knowingly participates in an illegal strike and any worker or union officer who knowingly participates in the commission of illegal acts during a strike may be declared to have lost his employment status, provided that mere participation of a worker in a lawful strike shall not constitute sufficient ground for termination of his employment, even if a replacement had been hired by the employer during such lawful strike. B. No person shall obstruct, impede, or interfere with, by force, violence, coercion, threats, or intimidation, any peaceful picketing by employees during any labor controversy, or in the exercise of their right to self-organization or collective bargaining, or shall aid or abet such obstruction or interference. C. No employer shall use or employ any strike breaker, nor shall any person be employed as a strike breaker. D. No public official or employee, including officers and personnel of the new Armed Forces of the Philippines or the Integrated National Police or armed person, shall bring in, introduce, or escort in any manner any individual who seeks to replace strikers in entering or leaving the premises of a strike area or work in place of the strikers. The police force shall keep out of the picket lines unless actual violence or other criminal acts occur therein, provided that nothing herein shall be interpreted to prevent any public officer from taking any measure necessary to maintain peace and order, protect life and property, and/or enforce the law and legal order. E. No person engaged in picketing shall commit any act of violence, coercion, or intimidation, or obstruct the free ingress to or egress from the employer's premises for lawful purposes, or obstruct public thoroughfares. 280. Improved offer balloting. In an effort to settle a strike, the Department of Labor and Employment shall conduct a referendum by secret ballot on the improved offer of the employer on or before the 30th day of the strike. When at least a majority of the union members vote to accept the improved offer, the striking workers shall immediately return to work and the employer shall thereupon readmit them upon the signing of the agreement. In case of a lockout, the Department of Labor and Employment shall also conduct a referendum by secret balloting on the reduced offer of the union on or before the 30th day of the lockout. When at least a majority of the board of directors or trustees or the partners holding the controlling interest in the case of a partnership vote to accept the reduced offer, the workers shall immediately return to work and the employer shall thereupon readmit them upon the signing of the agreement. 281. Requirement for arrest and detention. Except on grounds of national security and public peace or in case of commission of a crime, no union members or union organizers may be arrested or detained for union activities without previous consultations with the Secretary of Labor. Chapter 2. Assistance to Labor Organizations. 282. Requirement for arrest and detention. The Department of Labor, at the initiative of the Secretary of Labor, shall extend special assistance to the organization for purposes of collective bargaining of the most underprivileged workers who, for reasons of occupation, organizational structure, or insufficient incomes, are not normally covered by major labor organizations or federations. 283. Assistance by the Institute of Labor and Manpower Studies. The Institute of Labor and Manpower Studies shall render technical and other forms of assistance to labor organizations and employer organizations in the field of labor education, especially pertaining to collective bargaining, arbitration, labor standards, and the labor code of the Philippines in general. Chapter 3. Foreign Activities. 284. Prohibition against aliens. Exceptions. All aliens, natural or juridical, as well as foreign organizations, are strictly prohibited from engaging directly or indirectly in all forms of trade union activities without prejudice to normal contacts between Philippine labor unions and recognized international labor centers. Provided, however, that aliens working in the country with valid permits issued by the Department of Labor and Employment may exercise the right to self-organization and join or assist labor organizations of their own choosing for purposes of collective bargaining. Provided, further, that said aliens are nationals of a country which grants the same or similar rights to Filipino workers. 285. Regulation of foreign assistance. A. No foreign individual, organization, or entity may give any donations, grants, or other forms of assistance, in cash or in kind, directly or indirectly, to any labor organization, group of workers, or any auxiliary thereof, such as cooperatives, credit unions, and institutions engaged in research, education, or communication in relation to trade union activities without prior permission by the Secretary of Labor. Trade union activities shall mean 1. Organization, formation, and administration of labor organization. 2. Negotiation and administration of collective bargaining agreements. 3. All forms of concerted union action. 4. Organizing, managing, or assisting union conventions, meetings, rallies, referenda, teach-ins, seminars, conferences, and institutes. 5. Any form of participation or involvement in representation proceedings, representation elections, consent elections, union elections, and C. Other activities or actions analogous to the foregoing. B. This prohibition shall equally apply to foreign donations, grants, or other forms of assistance, in cash or in kind, given directly or indirectly to any employer or employer's organization to support any activity or activities affecting trade unions. C. The Secretary of Labor shall promulgate rules and regulations to regulate and control the giving and receiving of such donations, grants, or other forms of assistance, including the mandatory reporting of the amounts of the donations or grants, the specific recipients thereof, the projects or activities proposed to be supported, and their duration. 286. Applicability to farm tenants and rural workers. The provisions of this title pertaining to foreign organizations and activities shall be deemed applicable likewise to all organizations of farm tenants, rural workers, and the like, provided that in appropriate cases the Secretary of Agrarian Reform shall exercise the powers and responsibilities vested by this title in the Secretary of Labor. Chapter 4. Penalties for Violation. 287. Penalties. A. Any person violating any of the provisions of Article 264 of this code shall be punished by a fine of not less than 1,000 pesos nor more than 10,000 pesos and or imprisonment for not less than 3 months nor more than 3 years or both such fine and imprisonment at the discretion of the court. Prosecution under this provision shall preclude prosecution for the same act under the revised penal code and vice versa. B. Upon the recommendation of the Minister of Labor and Employment and the Minister of National Defense, foreigners who violate the provisions of this title shall be subject to immediate and summary deportation by the Commission on Immigration and Deportation and shall be permanently barred from re-entering the country without the special permission of the President of the Philippines. Title 9 Special Provisions 288 Study of Labor Management Relations. The Secretary of Labor shall have the power and it shall be his duty to inquire into a. The existing relations between employers and employees in the Philippines, b. The growth of associations of employees and the effect of such associations upon employer-employee relations, c. The extent and results of the methods of collective bargaining in the determination of terms and conditions of employment, d. The methods which have been tried by employers and associations of employees for maintaining mutually satisfactory relations, e. Desirable industrial practices which have been developed through collective bargaining and other voluntary arrangements, f. The possible ways of increasing the usefulness and efficiency of collective bargaining for settling differences, G. The possibilities for the adoption of practical and effective methods of labor management cooperation. H. Any other aspects of employer-employee relations concerning the promotion of harmony and understanding between the parties, and I. The relevance of labor laws and labor relations to national development. The Secretary of Labor shall also inquire into the causes of industrial unrest and take all the necessary steps within his power as may be prescribed by law to alleviate the same, and shall from time to time recommend the enactment of such remedial legislation as in his judgment may be desirable for the maintenance and promotion of industrial peace. 289 Visitorial Power. The Secretary of Labor and Employment or his duly authorized representative is hereby empowered to inquire into the financial activities of legitimate labor organizations upon the filing of a complaint under oath and duly supported by the written consent of at least 20% of the total membership of the labor organization concerned, and to examine their books of accounts and other records to determine compliance or non-compliance with the law and to prosecute any violations of the law in the Union Constitution and bylaws, provided that such inquiry or examination shall not be conducted during the 60-day freedom period nor within the 30 days immediately preceding the date of election of Union officials. 290. Tripartism, Tripartite Conference, and Tripartite Industrial Peace Councils. A. Tripartism in labor relations is hereby declared a state policy. Towards this end, workers and employers shall, as far as practicable, be represented in decision and policy-making bodies of the government. B. The Secretary of Labor and Employment or his duly authorized representatives may from time to time call a national, regional, or industrial tripartite conference of representatives of government, workers and employers, and other interest groups as the case may be, for the consideration and adoption of voluntary codes or principles designed to promote industrial peace based on social justice or to align labor movement relations with established priorities in economic and social development. In calling such conference, the Secretary of Labor and Employment may consult with accredited representatives of workers and employers. C. A National Tripartite Industrial Peace Council (NTIPC) shall be established, headed by the Secretary of Labor and Employment, with 20 representatives each from the labor and employer sectors to be designated by the President at regular intervals. For this purpose, a sectoral nomination, selection, and recall process shall be established by the DOLE in consultation with the sectors observing the most representative organization criteria of ILO Convention No. 144. Tripartite Industrial Peace Councils (TIPCs) at the regional or industry level shall also be established with representatives from government, workers, and employers to serve as a continuing forum for tripartite advisement and consultation in aid of streamlining the role of government, empowering workers and employees organizations, enhancing their respective rights, attaining industrial peace, and improving productivity. The TIPC shall have the following functions: 1. Monitor the full implementation and compliance of concerned sectors with the provisions of all tripartite instruments, including international conventions and declarations, codes of conduct, and social accords. 2. Participate in national, regional, or industry-specific tripartite conferences, which the President or the Secretary of Labor and Employment may call from time to time. 3. Review existing labor, economic, and social policies and evaluate local and international developments affecting them. 4. Formulate, for submission to the President or to Congress, tripartite views, recommendations, and proposals on labor, economic, and social concerns, including the presentation of tripartite positions on relevant skills pending in Congress. 5. Advise the Secretary of Labor and Employment in the formulation or implementation of policies and legislation affecting labor and employment. 6. Serve as a communication channel and a mechanism for undertaking joint programs among government, workers, employers, and their organizations toward enhancing labor management relations. And 7. Adopt its own program of activities and rule consistent with development objectives. All TIPCs shall be an integral part of the organizational structure of the NTIPC. The operations of all TIPCs shall be funded from the regular budget of the DOLE. 291. Government Employees. The terms and conditions of employment of all government employees, including employees of government-owned and controlled corporations, shall be governed by the Civil Service Law, rules, and regulations. Their salaries shall be standardized by the National Assembly as provided for in the new Constitution. However, there shall be no reduction of existing wages, benefits, and other terms and conditions of employment being enjoyed by them at the time of the adoption of this code. 292. Miscellaneous Provisions. A. All unions are authorized to collect reasonable membership fees, union dues, assessments, and fines and other contributions for labor education and research, mutual death and hospitalization benefits, welfare fund, strike fund, and credit and cooperative undertakings. B. Subject to the constitutional right of workers to security of tenure and their right to be protected against dismissal, except for a just and authorized cause and without prejudice to the requirement of notice under Article 283 of this code, the employer shall furnish the worker whose employment is sought to be terminated a written notice containing a statement of the causes for termination and shall afford the latter ample opportunity to be heard and to defend himself with the assistance of his representative, if he so desires in accordance with company company rules and regulations promulgated pursuant to guidelines set by the Department of Labor and Employment. Any decision taken by the employer shall be without prejudice to the right of the worker to contest the validity or legality of his dismissal by filing a complaint with the regional branch of the National Labor Relations Commission. The burden of proving that the termination was for a valid or authorized cause shall rest on the employer. The Secretary of the Department of Labor and Employment may suspend the effects of the termination pending resolution of the dispute in the event of a prima facie finding by the appropriate official of the Department of Labor and Employment before whom such dispute is pending that the termination may cause a serious labor dispute or is in implementation of a mass layoff. C. Any employee, whether employed for a definite period or not, shall, beginning on his first day of service, be considered as an employee for purposes of membership in any labor union. D. No docket fee shall be assessed in labor standards disputes. In all other disputes, docket fees may be assessed against the filing party, provided that in bargaining deadlock, such fees shall be shared equally by the negotiating parties. E. The Minister of Labor and Employment and the Minister of the Budget shall cause to be created or reclassified in accordance with law such positions as may be necessary to carry out the objectives of this code and cause the abrogating of the salaries of the personnel involved in the labor relations system of the ministry. Funds needed for this purpose shall be provided out of the Special Activities Fund appropriated by Batas Pambansa bilang 80 and from annual appropriations thereafter. F. A special voluntary arbitration fund is hereby established in the board to subsidize the cost of voluntary arbitration in cases involving the interpretation and implementation of the collective bargaining agreement, including the arbitrator's fees and for such other related purposes to promote and develop voluntary arbitration. The board shall administer the special voluntary arbitration fund in accordance with the guidelines it may adopt upon the recommendation of the council, which guidelines shall be subject to the approval of the Secretary of Labor and Employment. Continuing funds needed for this purpose in the initial yearly amount of 15 million pesos shall be provided in the 1989 Annual General Appropriations Acts. The amount of subsidy in appropriate cases shall be determined by the board in accordance with established guidelines issued by it upon the recommendation of the council. The fund shall also be utilized for the operation of the council, the training and education of voluntary arbitrators, and the voluntary arbitration program. G. The ministry shall help promote and gradually develop, with the agreement of labor organizations and employers, labor management cooperation programs at appropriate levels of the enterprise based on the shared responsibility and mutual respect in order to ensure industrial peace and improvement in productivity, working conditions, and the quality of working life. H. In establishments where no legitimate labor organization exists, labor management committees may be formed voluntarily by workers and employers for the purpose of promoting industrial peace. The Department of Labor and Employment shall endeavor to enlighten and educate the workers and employers on their rights and responsibilities through labor education, with emphasis on the policy thrusts of this code. I. To ensure speedy labor justice, the periods provided in this code within which decisions or resolutions of labor relations cases or matters should be mandatory. For this purpose, a case or matter shall be deemed submitted for decision or resolution upon the filing of the last pleading or memorandum required by the rules of the Commission, or by the Commission itself, or the labor arbiter, or the director of the Bureau of Labor Relations and mayor arbiter, or the regional director. Upon expiration of the corresponding period, a certification stating why a decision or resolution has not been rendered within the said period shall be issued forthwith by the chairman of the commission, the executive labor arbiter, or the director of the Bureau of Labor Relations and mayor arbiter, or the regional director as the case may be, and a copy thereof served upon the parties. Despite the expiration of the applicable mandatory period, the aforesaid officials shall, without prejudice to any liability which may have been incurred as a consequence thereof, see to it that the case or matter shall be decided or resolved without any further delay. Book 6, Post-Employment, Title 1, Termination of Employment, 293, Coverage. The provisions of this title shall apply to all establishments or undertakings, whether for profit or not. 294. Security of tenure. In cases of regular employment, the employer shall not terminate the services of an employee except for a just cause or when authorized by this title. An employee who is unjustly dismissed from work shall be entitled to reinstatement without loss of seniority rights and other privileges, and to his full back wages, inclusive of allowances, and to his other benefits or their monetary equivalent, computed from the time his compensation was withheld from him up to the time of his actual reinstatement. 295. Regular and casual employment. The provisions of written agreement to the contrary notwithstanding, and regardless of the oral agreement of the parties, an employment shall be deemed to be regular where the employee has been engaged to perform activities which are usually necessary or desirable in the usual business or trade of the employer, except where the employment has been fixed for a specific project or undertaking, the completion or termination of which has been determined at the time of the engagement of the employee, or where the work or service to be performed is seasonal in nature and the employment is for the duration of the season. An employment shall be deemed to be casual if it is not covered by the preceding paragraph, provided that any employee who has rendered at least 1 year of service, whether such a service is continuous or broken, shall be considered a regular employee with respect to the activity in which he is employed, and his employment shall continue while such activity exists. 296. Probationary Employment. Probationary employment shall not exceed 6 months from the day the employee started working unless it is covered by an apprenticeship agreement stipulating a longer period. The services of an employee who has been engaged on a probationary basis may be terminated for a just cause or when he fails to qualify as a regular employee in accordance with reasonable standards made known by the employer to the employee at the time of his engagement. An employee who is allowed to work after a probationary period shall be considered a regular employee. 297. Termination by employer. An employer may terminate an employment for any of the following causes. A. Serious misconduct or willful disobedience by the employee of the lawful orders of his employer or representative in connection with his work. B. Gross and habitual neglect by the employee of his duties. C. Fraud or willful breach by the employee of the trust reposed in him by his employer or duly authorized representative. D. Commission of a crime or offense by the employee against the person of his employer or any immediate member of his family or his duly authorized representatives. And E. Other causes analogous to the foregoing. 298. Closure of establishment and reduction of personnel. The employer may also terminate the employment of any employee due to the installation of labor-saving devices, redundancy, retrenchment to prevent losses, or the closing or cessation of operation of the establishment or undertaking unless the closing is for the purpose of circumventing the provisions of this title by serving a written notice on the workers and the Ministry of Labor and Employment at least 1 month before the intended date thereof. In case of termination due to the installation of labor-serving devices or redundancy, the worker affected thereby shall be entitled to a separation pay equivalent to at least 1 month pay or to at least 1 month pay for every year of service, whichever is higher. In case of retrenchment to prevent losses, and in cases of closures or cessation of operations of establishment or undertaking not due to serious business losses or financial reverses, the separation pay shall be equivalent to 1 month pay or at least 1/2 month pay for every year of service, whichever is higher. A fraction of at least 6 months shall be considered 1 whole year. 299. Disease as ground for termination. An employer may terminate the services of an employee who has been found to be suffering from any disease and whose continued employment is prohibited by law or is prejudicial to his health as well as to the health of his co-employees, provided that he is paid separation pay equivalent to at least 1 month's salary or to 1/2 month's salary for every year of service, whichever is greater, a fraction of at least 6 months being considered as 1 whole year. 300. Termination by employee. A. An employee may terminate without just cause the employee-employer relationship by serving a written notice on the employer at least 1 month in advance. The employer upon whom no such notice was served may hold the employee liable for damages. B. An employee may put an end to the relationship without serving any notice on the employer for any of the following just causes. 1. Serious insult by the employer or his representative on the honor and person of the employee. 2. inhuman and unbearable treatment accorded to the employee by the employer or his representative. 3. Commission of a crime or offense by the employer or his representative against the person of the employee or any of the immediate members of his family. And 4. Other causes analogous to any of the foregoing. 301. When employment not deemed terminated, the bona fide suspension of the operation of a business or undertaking for a period not exceeding 6 months or the fulfillment by the employee of a military or civic duty shall not terminate employment. In all such cases, the employer shall reinstate the employee to his former position without loss of seniority rights if he indicates his desire to resume his work not later than 1 month from the resumption of operations of his employer or from his relief from the military or civic duty. Title II. Retirement from the Service. 302. Retirement. Any employee may be retired upon reaching the retirement age established in the collective bargaining agreement or other applicable employment contract. In case of retirement, the employee shall be entitled to receive such retirement benefits as he may have earned under existing laws and any collective bargaining agreement and other agreements, provided, however, that an employee's retirement benefits under any collective bargaining and other agreements shall not be less than those provided therein. In the absence of a retirement plan or agreement providing for retirement benefits of employees in the establishment, an employee upon reaching the age of 60 years or more, but not beyond 65 years, which is hereby declared the compulsory retirement age, who has served at least 5 years in the said establishment, may retire and shall be entitled to retirement pay equivalent to at least 1/2 month's salary for every year of service, a fraction of at least 6 months being considered as 1 whole year. Unless the parties provide for broader inclusions, the term 1/2 month's salary shall mean 15 days plus 1/12 of the 13th month pay and the cash equivalent of not more than 5 days of service incentive leaves. An underground mining employee, upon reaching the age of 50 years or more but not beyond 60 years, which is hereby declared the compulsory retirement age for underground mine workers, who has served at least 5 years as underground mine worker, may retire and shall be entitled to all the retirement benefits provided for in this article. Retail, service, and agricultural establishments or operations employing not more than 10 employees or workers are exempted from the coverage of this provision. Violation of this provision is hereby declared unlawful and subject to the penal provisions under Article 303 of this Code. Nothing in this article shall deprive any employee of benefits to which he may be entitled under existing laws or company policies or practices. Book 7, Transitory and Final Provisions, Title 1, Penal Provisions and Liabilities. 303, Penalties. Except as otherwise provided in this code or unless the acts complained of hinge on a question of interpretation or implementation of ambiguous provisions of an existing collective bargaining agreement, any violation of the provisions of this code declared to be unlawful or penal in nature shall be punished with a fine of not less than 1,000 pesos nor more than 10,000 pesos or imprisonment of not less than 3 months nor more than 3 years or both, such fine and imprisonment at the discretion of the court. In addition to such penalty, any alien found guilty shall be summarily deported upon completion of service of sentence. Any provision of law to the contrary notwithstanding, any criminal offense punished in this code shall be under the concurrent jurisdiction of the municipal or city courts and the courts of first instance. 304. Who are liable when committed by other than natural person. If the offense is committed by a corporation, trust, firm, partnership, association, or any other entity, the penalty shall be imposed upon the guilty officer or officers of such corporation, trust, firm, partnership, association, or entity. Title 2. Prescription of Offenses and Claims. 305. Offense. Offenses penalized under this code and the rules and regulations issued pursuant thereto shall prescribe in 3 years. All unfair labor practice arising from Book 5 shall be filed with appropriate agency within 1 year from accrual of such unfair labor practice. Otherwise, they shall be forever barred. 306. Money claims. All money claims arising from employer-employee relations accruing during the effectivity of this code shall be filed within 3 years from the time the cause of action accrued. Otherwise, they shall be forever barred. All money claims accruing prior to the effectivity of this code shall be filed with the appropriate entities under this code within 1 year from the date of effectivity, and shall be processed or determined in accordance with the implementing rules and regulations of the code. Otherwise, they shall forever be barred. Workmen's compensation claims accruing prior to the effectivity of this code and during the period from November 1, 1974 up to December 31, 1974 shall be filed with the appropriate regional offices of the Department of Labor not later than March 31, 1975. Otherwise, they shall forever be barred. The claims shall be processed and adjudicated in accordance with the law and rules at the time their causes of action accrued. 307. Institution of money claims. Money claims specified in the immediately preceding article shall be filed before the appropriate entity independently of the criminal action that may be instituted in the proper courts. Pending the final determination of the merits of money claims filed with the appropriate entity, no civil action arising from the same cause of action shall be filed with any court. This provision shall not apply to employees' compensation case, which shall be processed and determined strictly in accordance with the pertinent provisions of this code. Title 8. Transitory and Final Provisions. 308. Application of laws enacted prior to this code. All actions or claims accruing prior the effectivity of this code shall be determined in accordance with the laws in force at the time of their accrual. 309. Secretary of Labor to initiate integration of maternity leave benefits. Within 6 months after this code takes effect, the Secretary of Labor shall initiate such measures as may be necessary for the integration of maternity leave benefits into the Social Security system in the case of private employment, and the government service insurance system in the case of public employment. 310. Funding of the Overseas Employment Development Board and the National Seamen's Board referred to in Articles 17 and 20, respectively, of this code, shall initially be funded out of the unprogrammed fund of the Department of Labor and the National Manpower and Youth Council. 311. Termination of the Workmen's Compensation Program. The Bureau of Workmen's Compensation, Workmen's Compensation Commission, and Workmen's Compensation Units in the regional offices of the Department of Labor shall continue to exercise the functions and the respective jurisdictions over workmen's compensation cases vested upon them by Act No. 3428 as amended, otherwise known as the Workmen's Compensation Act, until March 31, 1976. Likewise, the term of office of incumbent members of the Workmen's Compensation Commission, including its chairman and any commissioner deemed retired as of December 31, 1975, as well as the present employees and officials of the Bureau of Workmen's Compensation, Workmen's Compensation Commission, and the Workmen's Compensation Units, shall continue up to that date. Thereafter, said offices shall be considered abolished, and all officials and personnel thereof shall be transferred to and mandatorily absorbed by the Department of Labor, subject to Presidential Decree No. 6, Letters of Instruction Numbers 14 and 14A in the Civil Service Law and Rules. Such amount as may be necessary to cover the operational expenses of the Bureau of Workmen's Compensation and the Workmen's Compensation Units, including the salaries of incumbent personnel for the period up to March 31, 1976, shall be appropriated from the unprogrammed funds of the Department of Labor. 312. Continuation of insurance policies and indemnity bonds. All workmen's compensation insurance policies and indemnity bonds for self-insured employers existing upon the effectivity of this code shall remain in force and effect until the expiration dates of such policies or the lapse of the period of such bonds as the case may be, but in no case beyond December 31, 1974.